Why you should pause and consult an ERISA disability attorney before you sign a severance agreement or a workers' compensation general release. Has your employer offered you a severance agreement in exchange for termination of your employment? Have you been injured on the job and agreed to settle your workers' compensation case by signing a general release? Do you know what you're giving up in that severance agreement or general release? If you don't know, you may be surprised to learn that you've given up some very, very important benefits. Let's learn more before you make a mistake that will cost you big time. Let's start out by talking about severance agreement. In this day and age, employers are offering employees buyouts and asking them to sign severance agreements in exchange for a lump sum of money and termination of employment. Do you know what's in that severance agreement? It's not unusual for it to be full of legal jargon and mumbo-jumbo that cites all sorts of laws, including ERISA. Now, the ERISA law governs employer-provided group health, life, pension, and disability benefits. What the employer is asking you to do in this general release is to give up your rights to your group health insurance, your life insurance, your pensions, and disability benefits. Your employer is asking that you give up vested benefits that have value. That's value that they're not putting on the table, hoping that you'll sign the release and go on your way, not knowing what you've given up. You have the right to negotiate, and you should be consulting with an experienced ERISA disability attorney to review that release. At a minimum, you want to carve out your right to claim ERISA benefits so that you can claim them in the future. You might want to address maintaining your life insurance, pension, and disability insurance benefits as part of the release, or demand additional compensation to allow you to maintain those benefits. If you sign the separation agreement with those terms in it, you're screwed. Well, is a workers' compensation settlement any different? Workers' compensation settlements are governed by state law, and each state is different. If you've been injured on the job, you're generally entitled to those benefits, and many times a case will result in a settlement. Your employer, their workers' comp carrier, or the state, depending on where you live, will offer you a lump sum settlement in exchange for a termination of employment and signature on general releases. As a workers' comp attorney, I know that unfortunately many workers' compensation attorneys just don't want to get involved in the releases. They'll leave you hanging, and in my view, that's a huge mistake and probably malpractice. Many times that general release will do the same thing as a separation agreement. You've given up vested rights, including your rights to claim disability insurance benefits or continue your health or life insurance benefits. If you've been injured on the job and have disability insurance benefits, you want to try to collect both. Now, I know that your employer and the work comp carrier are trying to screw you out of your disability benefits by having you sign a release. And that's what happened to Ms. Holmes, who was injured when she worked for Becker Corporation. She was injured in a workers' compensation case. She was offered a separation agreement and a general release of legal claims for the whopping sum of $250. She signed the release that encouraged her to consult an attorney before signing. The release affirmatively and explicitly waived any claim she had for her ERISA disability benefits. So guess what? When she applied for her long-term disability benefits, they were denied in part on the basis that she gave up her ERISA benefits as part of her workers' compensation and employer severance agreement. So what did the court say about the enforceability of these releases? In the case of Holmes versus Prudential Insurance Company of America, an Arkansas case, the court noted that Holmes was explicitly advised that she would be waiving her ERISA disability claim and that she should consult with an attorney before signing a release and agreeing to give up her benefits, and that she had ample time to do so before she signed the agreement. The court rejected her argument that the whopping sum of $250 in consideration constituted a violation of her employer and Prudential's fiduciary duties, and the court found she knowingly waived her ERISA disability benefits. What a costly mistake she made by failing to have her agreement and workers' comp documents reviewed by an attorney. If you're disabled and you've been offered a severance agreement by your employer, or you're planning on applying for your ERISA disability benefits after your termination, stop. Don't sign any agreement before you contact an ERISA disability attorney like myself. And the same holds true if you're asked to sign a workers' compensation settlement or a release. In either case, you're giving up valuable benefits that could be preserved had you just consulted with an experienced ERISA disability attorney. So don't delay. Call me to learn more about your rights to your long-term disability benefits and why you don't want to sign a severance agreement or a workers' compensation agreement unless you've consulted with an experienced attorney. I can help you regardless of where you live in the United States. Call today at 727-894-3188 and don't give up valuable rights in exchange for a lump sum settlement or buyout agreement.